Pauras, it is now 4 years since we last interviewed you here up in Catherine's, and this is to do with your house and trees affecting the structure, the substance of your house. And there was an interview from 4 years ago. Have you made any progress, or that is to say, by the fact that we're here today in 2021, have there been no progress?
You're correct, there's been no progress. But for you and your viewers, it's very strange. Because we don't even have a dispute. There's no dispute at all. Our experts have said damage has been caused to our property by Harlow Council trees. Harlow Council's representatives, the Zurich subsidence team, has written to us and has actually said, and I'll give it to you here, further to the recent site investigations that were carried out to the foundations of the brickwork garden wall, I can confirm that the tree roots have been causing physical damage to the foundations and the brickwork. The tree roots have encroached to the underside of the foundations and have physically displaced the foundations, causing the cracking to the brickwork. We have enclosed a copy of the site investigations that have been carried out, and you may use these to make your own case to the council to mitigate the damage. Now, that was in 2013, 21st of November 2013. They were part, in the following year, 2014, of the Zurich subsidence team. That states on their website, the Zurich subsidence team website, our in-house resource is supplemented by a partnership with Cunningham Lindsay subsidence experts. So that's just one. The other one is Zurich brought in Waitmans to challenge their own subsidence team, which is contrary to the civil procedure rules laid down mandatory by the court. And the Waitmans actually confirmed subsidence damage in writing by Harlow Council's trees to our property.
Okay, can I just cut in there and say, have you actually been able to get into court? What progress have you made since 2017, if any?
Well, that is a very good point, and I'm glad you asked that. We have not made any progress at all with regards to our insurers. Our insurers have acted, in my view, totally dishonestly. They have, I'll give you an example, I've made some notes. 12th of December 2013, our insurers wrote to us, although our regulator insists that the policy underwriters handle the detail of your complaint, we have a specialist department that monitors the performance of our suppliers, and they have been made aware of the issues you have raised, so they too can monitor the situation. So in effect, our insurers have taken out our claim from the insurance system because the underwriter is responsible for monitoring the claim. The underwriter is responsible for paying the solicitors.
So have you made an insurance claim that's been refused?
No.
All right, so no insurance claim?
No. You asked, have we made an insurance claim that's been refused? We have made
an insurance claim.
We've made an insurance claim.
How's it getting on?
We've had 4 solicitors, all of whom have ignored the civil procedure rules. Now that's important. I've nearly lost my life twice due to stress caused by Harlow Council. This did not need to go to insurance. Had Harlow Council acted legally and honestly. Now, there's something that's important that needs to be explained to you and your viewers. There's something called the civil procedure rules, which I mentioned earlier. Let me just read out what the court states. It's on the government's justice website. Before commencing proceedings, the courts will expect the parties to have engaged sufficient information to A, understand each other's position, B, make decisions about how to proceed, C, try to settle the issues without proceedings, D, consider a form of alternative dispute resolution such as mediation, E, support the efficient management of these proceedings, and F, reduce the costs of resolving the dispute. And something very, very, very important that your viewers need to know. It's about their expectations. I believed what you do, you get the evidence. Then you go to the other party and say, we've got the evidence. No. As going back to it, says you make decisions with the other party as to how to proceed. This is what the court says about evidence. Parties should be aware that the court must give permission before expert evidence can be relied upon. So they could actually throw it out if you don't actually agree it with the court and the other party. And that the courts may limit the fees recoverable. Many disputes can be resolved without expert advice or evidence. If it is necessary to obtain expert evidence, particularly in low-value claims, the parties should consider using a single expert jointly instructed by the parties with the costs shared equally. So, let me explain what has happened and what should have happened. I'll actually do the reverse. I'll tell you what I think should have happened according to the civil procedure rules. Our solicitor, back in 2010, should have contacted Zurich Municipal and said, look, we've got a client here, Mr. Kolah. He's alleging that Harlow Council trees have caused damage to his, or are going to cause damage to his property. We need to act because Harlow Council refused to act. The Harlow Council have advised they could remove the tree one in their email of the 29th September 2010 and haven't. They said they were going to lay a root barrier. Not only did they not lay the root barrier, but they lied and said that Mr. Kolah asked for the root barrier, even though it's documented in the 29th September 2010 email from Harlow Council saying that they have strongly recommended the root barrier to deter future root encroachment. And the third thing is Harlow Council said they should limit the height of the trees for water uptake. And that's against the Harlow Council tree policy.
Okay. I'm getting aware of things from 2010, 2013. I interviewed in 2017. I'm getting no sense that anything's happened between 2017 and 2021.
No, but I'm going back to your original question, Michael,
right,
where you asked me what's happened with regards to the insurance policy.
Okay.
Yeah. Now, what I'm saying, what's important, which we cannot overlook, is that we've had 4 solicitors, 3 of whom are on the panel of solicitors for our insurer, all ignored the court's mandatory civil procedure rules. If the solicitors followed civil procedure rules, we wouldn't be talking right now. This matter would have been resolved, guaranteed. Because we've got the law on our side, we've got evidence of Harlow misconduct in a public office on our side, we've got evidence from structural engineering and tree experts on our side, we've got even admissions from Harlow Council's representatives and Zurich's representatives on our side, and we've even got a letter going back to 2010 written to a neighbour saying, yes, the trees have the potential to cause damage, and that was after Harlow Council did the works in 2010, which were proven to be inadequate.
So 10 minutes into the interview, why aren't you making any progress?
Because there's a wall of silence against us by not only Harlow Council, but also by our councillors. And I'll answer your question again, because it's an important question, and I'll thank you for it. In 2016, and as you are going to be contacting Harlow Council for a right of reply. In 2016, the head of governance, Mr. Brian Keane, wrote to me in his letter 2nd of February 2016, and I quote, "The council has reviewed the case and still consider your complaints to be vexatious, and I am notifying you that the council will not be responding any further to the points you have raised in your emails, as they are still deemed to be vexatious without substance. Therefore, a decision has been made to confirm that a level 3 vexatious restriction will remain in place until December 2019. And if he had done a review, please ask Mr. Keane why it's had no substance in his view, when the evidence we have is Harlow Council officer lying on the 4th of November 2010, that was proven by Harlow Council's letter 2nd of May, when that officer at Robert Halpin's meeting promised the root barrier to us and then said, I asked for the root barrier in the 4th of November letter. That was part of a complaint procedure. Then also evidence of officers forging a letter in the complaints procedure, where the officer a few weeks earlier in front of Robert Halpin promised the root barrier, and then in his letter to me on the 4th of November said, I had spoken to officers centrally involved in this matter and I understand a footpath needs maintaining. Well, Essex County Council were there and we were all joint talking about the footpath. So why would he have to say that when he was the officer centrally involved? And then I'll just finish this, please. Then he said, I wanted an alternative procedure in this letter, that I wanted a root barrier. Not only did he promise that, but in a joint email, 29th of September, they confirmed that a root barrier was to be laid to deter future root encroachment. But Mr. Keane said he'd done a review. If he's done a review, then he would know that my complaint is also based on a Marshall Thompson tree expert report that criticised Harlow Council for the works they had done. My complaint is based on the Cunningham-Lindsay letter and laboratory report proving tree roots have gone underneath the foundations, displaced the foundations, causing crack into the brickwork. My complaint is also supported by Waitmans, the solicitors representing Harlow Council and Zurich Municipal, that confirmed subsidence damage to our property by Harlow Council tree roots. My complaint is also supported by the BBC Rip-Off Britain scans of Harlow Council land, showing that the roots are deep and growing towards our property, where in 2012 Zurich said there were no roots.
So what?
And finally, I'm sorry.
What happens now, though? Because I get the feeling, one way or the other, that I could come back in 2025 and we're still going to be here. Now,
I'm glad you raised that. That is a very, very good question. It does appear to say, if I'm correct, and please correct me if I'm wrong, you're saying, what are you going to do now?
Yeah.
That's an important question. Why should I have to do anything, Michael? The onus is on the local authority to abide by their legal duty of care where they have the evidence. And there's something called the 7 Nolan Principles. And one of them is objectivity. Holders of public office, such as Mr. Keane, such as councillors, such as the MP, must act and take decisions impartially, fairly, and on merit, using the best evidence and without discrimination or bias. The question needs to be put to Harlow Council when they have the evidence of damage to our property, when they actually promised, after Mr. Keane's letter of 2016, they actually promised Councillor John Strachan, Director of HTS, promised, he came to our home in July 2018 and said, an arborist has been round, the trees will be removed, that are causing damage to your property. Confirmed by another councillor, Jean Clark, in August 16th, 2018 on the phone. I recorded the conversation because of all the lies that we had received. So it's documented, and she's even sent an email saying, I think there was a dispute over which trees were causing damage to your property. I think I gave you that email as well, Michael. So, and I've even had to go to the police about this. And the police can't even, would you believe, 15, 16 months later, cannot get a statement out of Harlow Council. Unbelievable. Now,
do you have an incident number from the police, by the way?
I do.
Okay.
And I'll let you have that after this, and I'll let you have everything else. So, I'm incredibly concerned that we've got a wall of silence against us, which is oppressive and it's fraudulent, because I've asked questions, and according to the Fraud Act, it says here it can be done by three things: fraud by false representation, and there was obviously a printed signature to Mr. I won't mention his name because he's left the council, but a 4th of November 2010 letter had a printed signature, and there was so many lies, it was written by somebody else. The second, fraud by failure to disclose information. Well, I've asked, the police have asked, and they're refusing to disclose information. And fraud by abuse of position. Well, Mr. Keane, I assume will get this copy of this video. It's my understanding that you've abused your position as head of government and you're abusing your position as the chief executive of Harlow Council, in my view,
right, because
you have the evidence and you're allowing damage to be continued to be made against our property. I find that discriminatory, particularly since HTS told your Harlow last year that any trees causing a risk to people or property will still be regarded as a priority. Now, my question is an important one. HTS Director John Strachan came here and told me the trees will be removed. Was John Strachan and Councillor Jean Clark lying? And if they were not lying, it's incredibly serious. Who took the trees out of the council's planned works to stop damage, and why? There are so many very serious unanswered questions. I'm not saying for 1 second Councillor John Strachan or Councillor Jean Clark are lying. If they're not lying, it's even more serious. And we need to have answers, because there's a wall of silence now. They know the answers since 2010 and not even told us. There's not even been a complaints process that's been treated correctly by Harlow Council. And that is also very serious. And they have it's all documented. Everything I tell you is documented. And it's incredibly serious. The police have copies of all the evidence as well.
Do you think, finally, because I make this a 20-minute interview, where are you going to go from here? Or do you feel that now you're just wound up in the whole process, or not actually making any real progress?
I think that's an important question. Where do we go from here? It's down to Harlow Council. Harlow Council can do one of two things, Michael. They can ignore the admissions and the evidence, and then they're breaking the law. They can explain to me why there was no proper complaints procedure in 2010 which would have resolved the matter. 11 years, I would not have had a heart attack. I would not have had sepsis. I would not have had chronic eczema. I would not be in and out of hospital. I would not have a stent in my heart right now. Bear in mind, I had my heart attack in 2016, November. Mr. King could have stopped it. He could have stopped it. In February 2016, he lied. He decided to lie, in my view. Now, they've got a choice. Either they continue to cause damage to our property, or they can say, Mr. Kolah, we hold our hands up, and we have done a number of things that are really wrong, and they shouldn't have happened. Now, as I've said to you, and I'll stress this to you, everything I am telling you and your viewers and the people of Harlow It's fully documented. It's never been challenged. The police have never challenged it. They've accepted my view. They've accepted my position.
Do you not feel, Pauras, that, you know, you're not being well and getting on in years? So that's my opinion. Yeah, and your mother's over there.
I think you're getting younger.
Well, maybe you are. Maybe you are. Sorry, I don't think.
No.
Do you think somebody needs to put the arm around you and say, "Leave it, leave it. You've made your point. You may have won some moral victories, but for the good of your health and the future, let it go, man."
Thank you for making that point. Let me explain. A lot of your viewers will say, look, Michael's absolutely right. It's a garden wall. Okay. Point one. Our lives have been ruined completely because of this. Can't walk away from that. Didn't have to be. Completely unnecessary if Harlow Council acted honestly. Point two. The cost of replacing the foundations and the wall in 2015 was over £12,000. Point three. We have had the Marshall Thompson Tree Expert Subsidence Report. We've had Cunningham Lindsay. We've had BBC Rip Off Britain. All the evidence shows that the cracks that started at the far end of the wall and now coming towards the house shows the roots are spreading, and there's two types of damage that could be caused and are being caused. One, direct damage by the roots. Two, because we have proven to have clay soil, they're shrinking the clay soil. That's indirect damage. The cracks to the wall measured by a contractor of Harlow Council said the nearest crack to your wall is just 4 meters away from your house. He said you are going to get subsidence damage to your house sooner or later unless something is done now. We have incredibly serious problems. I often think, to be fair, what would my life have been, my mother's life have been, who's 84 this December, what would our lives have been if we didn't have this hanging over our heads? If Harlow Council acted honestly with us, kept the promises they made in front of Robert Halfon, protected our property, and did the right thing by their tree policy, which was to remove the tree.
So in conclusion, you're not giving up anytime soon?
I can't. The alternative is to say, Harlow Council, you were right to abuse us, abuse civil law, abuse criminal law, and cause damage to our property and cause permanent damage to my health. But that's a serious implication.
And we will put these questions to Harlow Council. Pauras, thank you very much.